We now turn to the discussion of the second major pillar in the non-discrimination regime of the WTO law, and this regime is called national treatment. As compared to MFN, it has a different scope of application and it applies to different types of measures. It applies to a very particular type of matters that we will be discussing. And here the comparison will not be as between the two foreign products competing against each other that we had in MFN. Here, the real comparison would happen as between the domestic product and the foreign product. And clearly, already from the name of the regime, you grasp the idea. It will be prohibited to discriminate a foreign product as compared to the domestic product. We would need to go in more detail in this regime. It will be a lengthy lecture, and you will also have to follow the reasoning I'm going to lay down with the text, because it will be really hard to follow with just watching the slides. So I again invite you to have your own text somewhere nearby. Make your marks in the text. It will greatly help you during the exam solving the questions. National treatment is also in the very beginning of the GATT. It's Article 3, and here I propose that we start with the general understanding on the scope and object and purpose of the national treatment obligation as was laid down by the appellate body in Japan Alcoholic Beverages case, which we will talk about in lengthy detail tonight. They say that the broad and fundamental purpose of Article 3 is to avoid protectionism in the application of internal tax and regulatory measures. More specifically, the purpose of Article 3 is to ensure that internal measures not be applied to imported or domestic products so as to afford protection to domestic production. Article 3 obligates members of the WTO to provide equality of competitive conditions for imported products in relation to domestic products. The intention of the drafters of the agreement was clearly to treat the imported products in the same way as the like domestic products once they have been cleared through customs. There are several important things I want to emphasize. To begin with, national treatment only turns on once the foreign product crossed the border. Because as long as we are talking of border measures, as long as we are talking of import operations, domestic products clearly do not face all those hurdles. Domestic products are already within the territory, and there is no need for them to be concerned about all those border restrictions that they may face. So on the one hand, Article 3, national treatment, only turns on when foreign products have already crossed the border, when they are already within our territory, within our customs territory. On the other hand, according to the statement made by the appellate body, you will see that ultimately the goal here is to avoid protectionism, and it will include many of those measures that we mentioned as possible means of protectionism during our kickoff exercise, in the application of two broad spheres, broad aspects of possible protectionism. This is internal taxation and regulatory measures. And ultimately, the goal is to provide equality of competitive conditions as amongst the domestic products and the foreign products. And this is exactly something you will see when reading through the text of Article 3, when interpreting it, you will see how important competitive conditions are, how important competitive opportunities are. And the appellate body emphasized many times that the WTO rules do not really protect real trade flows. They are not protecting from injuries to domestic industries. The only time when injuries would matter for the domestic industry or for the foreign industry would be those trade remedies we already mentioned on anti-dumping, countervailing duties. safeguards. So this is only the only case when injuries really matter. WTO rules otherwise are not about injuries, they're about competitive opportunities. And foreign products can even increase their market shares. They may not suffer specific losses that we can trace through, say, analysis of their financial standing or through their profits or whatever, their market share. They can increase the market share, but still the competitive opportunities will be to their disadvantage. So MFN and national treatment are non-discriminatory provisions. National treatment ensures that our domestic products are not treated more favorably than the like foreign products. And here you may see that the scope is internal taxation and regulatory measures. So if we would actually start reading the text of Article 3, we start with 3.1. That is the general obligation. It does not contain a very specific, detailed legal rule that we will be applying, but it will give us the flavor of all the analysis that is forthcoming. So here is how national treatment is determined by the drafters of the GATT in 1947. The contracting parties recognize that internal taxes and other internal charges and laws, regulations, and requirements affecting the sale, the internal sale, offering for sale, purchase, transportation, distribution, or use of products, and internal quantitative regulations requiring the mixture, processing, or use of products in specified amounts or proportions should not be applied to imported or domestic products so as to afford protection to domestic production. So these two, well, actually, there are two parts of this provision, but now let's just try to figure out what are the major components of it, and therefore we will actually understand the path of our discussion further in this lecture. So to begin with, this discrimination as between foreign and domestic products in favor of the domestic product is not possible with respect to internal taxes and other internal charges. Internal taxes and internal charges will be a big portion of discussion today, and we will have to understand how actually these rules work with internal taxes and internal charges. Then, it also prohibits, this provision also prohibits discrimination of foreign products as compared to the like domestic products in respect of laws, regulations, requirements that affect the internal sale, offering for sale, purchase, transportation, distribution, or use of products. So whenever you start reading such provisions, try to immediately invent an occasion that in your view could, any situation that could illustrate the violation of this provision. So if we say internal taxes that discriminate foreign products, it is simple. We say that a foreign product is subject to a, say, 10% sales tax. The domestic product is subject to 5% sales tax. It may be more tricky to imagine any discrimination with respect to laws, regulations, and requirements affecting the internal sale, offering for sale, purchase, transportation, distribution, or use of a product. But it is still not that difficult. You could come up with thousands of such possible discriminatory regulatory measures. We could say, for instance, that no foreign product could be sold in a shop, in a particular shop. Or we could say that no foreign product could be placed on a higher shelf. It can only be sold at the lowest shelves in the supermarket. Or we could say that foreign products could not be transported by, say, railroads. Russian railroads cannot accept foreign products for transportation. Or we could say that the distributors can only sell foreign products in certain restrictions. Say, we cannot sell foreign cars in any shop that will be located closer than 100 kilometers from any city in Russia. If you want to buy a foreign shop, if you want to buy a foreign car, please go to the remote shop and buy there. Use of products, we could restrict the use of foreign products. We could say that our, for instance, the use of a foreign phone necessarily requires a license or a permit or any additional education to be obtained, any qualification to be obtained by the user, and therefore foreign phones will be discriminated against like domestic products. Offering for sale, advertisement, distribution, rules on packaging. We could say that all foreign products should necessarily be sold in distant, separate refrigerators, say in a shop. They should be packed in non-transparent black packaging with a huge import word in red and in capital letters placed. So there can be various inventive steps governments could do in order to restrict imports through such regulatory measures. So always keep in mind those options that are prohibited. So please do always, when we will be talking about these types of measures in this lecture today, keep in mind those examples which will make the understanding of legal material easier for you. When would these restrictions be possible? When would restrictions be not possible? What sort of discrimination could we still justify? What sort of discrimination will be easier to challenge, or what sort of discrimination will be more difficult to challenge? This is something we need to understand today. But even this is not all. Article 3 will be talking about internal quantitative regulations requiring the mixture, processing, or use of products in specified amounts or proportions. This is a more specific example of actually those administrative measures which we were just talking about, when we would say that, for instance, in order to be labeled as, say, eco oil or eco petrol, yes, for instance, no less than 70% of petrol shall be produced from non-conventional sources, for instance. And again, labeling a product as eco or not eco may be subject to such restrictions, which will influence trade and will influence competitive opportunities. If we develop such rules that will either de jure or de facto favor domestic producers, it will also go contrary to national treatment obligations. And ultimately, what is the basic obligation? So all that, what we discussed, all those examples, all those types of measures, taxes, regulatory measures, internal quantitative regulations requiring the mixture processing of products, should not be applied to imported product, and to imported or domestic products, so as to afford protection to domestic production. So that is the general wording that prohibits protectionism, and that is exactly what national treatment is against. We do not wish to have any protectionism in sort of discriminatory taxation, discriminatory regulatory measures, or discriminatory requirements on mixtures of products, processing, use, mixtures. So summing it up, I tried to draw this table and give you the feeling of the discussions we are going to have. Internal taxes and other internal charges are subject to their specific rules under Article 3, which are contained in Article 3.2. Laws, regulations, requirements are subject to their specific regulations in Article 3.4. And internal regulations on mixture processing and use are in 3.5, 3.7. I will not be actually talking much of internal regulations on mixture processing and use of products, for a simple reason that they are a more specific situation as compared to 3.4, to laws, regulations, requirements affecting the use, sale of products. And fundamentally, the obligations there do not differ that much. If you ever need to deal with this type of restrictions, please consult Article 3.5, 3.6, 3.7. However, for our purposes, the basic understanding that is absolutely essential, that is the minimum requirement within this course, is understanding of the provisions in 3.2 and 3.4. We need clearly to understand how these work, how these are implemented, how they are interpreted, and we need to be able to apply those provisions ourselves when resolving cases. There was a number of disputes where the question was whether these two provisions, like Article 3.2 and 3.4, can apply simultaneously. And the most straightforward statement in that sense was made by the panel in Brazil taxation case, when it was said it is well established that a single measure can be inconsistent with two or more provisions of Article 3 at the same time. So a measure can, a law or whatever regulation we are talking about, can violate both Article, say, 3.2 and 3.4. This is because multiple features of a single measure may operate simultaneously. In such a situation, different aspects of the same measure could be considered to be covered by the disciplines of either or both Articles 3.2 and 3.4. So what could be the example? The examples, well, there was a very well-known case called Mexico soft drinks. And it was a question of the tax itself. What was the tax on soft drinks as implemented by Mexico? But on the other hand, it was also a question of the administration of this tax. What sort of documents need to be submitted? What sort of evidence you need to demonstrate to the tax authorities to prove the application of the tax burden chosen? And generally, what are the rules on administration, time-wise, paper-wise? So all these matters would fall within Article 3.4, whereas the questions of the differentiation, discrimination of the tax burden itself will be subject to Article 3.2. So clearly, one and the same measure can fall within the same within two provisions of Article 3. However, we need to distinguish the scope of each of the parts of the general obligation, and we need to understand what sort of a measure we are considering. If we will be talking about fiscal measures, measures that relate to taxes, charges, payments, anything that is price-based, we are talking of Article 3.2, and we apply the tests from Article 3.2. If we are focusing on a measure which is more regulatory in nature, which does not deal with taxation, which does not deal with payments, charges, then we are within the ambit of Article 3.4. So Article 3.2 is more specific. It deals with taxes, charges, payments. And then if we have a tax, and you know that in most countries, taxes are introduced also through laws, so potentially we could say that all measures are laws, regulations, and requirements in the field of taxation, but still here the specific rules shall apply. So Article 3.2 with respect to fiscal measures, Article 3.4 with respect to regulatory administrative measures that regulate international trade. Now let's switch to Article 3.2, internal taxation. A little lengthy and a little difficult in reading, but that is the challenge we need to overcome. Let's first read the provision itself as it reads. 3.2. The products of the territory of any contracting party imported into the territory of any other contracting party shall not be subject, directly or indirectly, to internal taxes or other internal charges of any kind in excess of those applied directly or indirectly to like domestic products. Moreover, no contracting party shall otherwise apply internal taxes or other internal charges to imported or domestic products, in a manner contrary to the principles set forth in paragraph 1. Having read that, I doubt that much was revealed. At least we understand that there are two sentences in these provisions. So one sentence finishes with the words "to like domestic products," full stop, and then the second sentence starts from the word "moreover." Now let's divide this, because unless we divide it, it's next to impossible to deal with this provision. In these two sentences, this is important, please note that these two sentences contain two separate legal obligations. So it is not just one obligation that is somehow additionally commented or developed in the second sentence. These are two separate legal obligations, two separate tests. And here, when analyzing a tax or a charge to make sure it is compatible with the provisions of Article 3.2, we would have to go and check both first and second sentence of Article 3.2 separately. What is there in the first sentence? Let's start with the first sentence. It says, once again, the products of the territory of any contracting party, the products from any WTO member, imported into the territory of any other contracting party, imported to the other WTO members, shall not be subject, directly or indirectly, to internal taxes or other internal charges of any kind, in excess of those applied directly or indirectly to like domestic products. So we understand that any foreign product, when imported in our territory, shall not be subject to taxes, charges, payments in excess of those which are applied to the like domestic product. So this is relatively simple and relatively straightforward. The second sentence contains a separate legal obligation. We now just read it. We will return to it later. Moreover, so this is something additional to what has just been said, no contracting parties shall otherwise apply internal taxes to imported or domestic products in a manner contrary to the principle set forth in paragraph 1. You remember what was there in paragraph 1, what were the principles? Paragraph 1 was saying that no internal taxes shall be applied so as to afford protection to the domestic production. So there can be no other way of applying taxes, internal taxes or other internal charges, in a manner that will still be discriminatory, that will be protectionist in favor of domestic production. So we will get back to the second sentence. Now let's focus on the first sentence. And now let's once again read it in order to try establish the test, to find out which are the elements that need to be demonstrated for us to challenge a tax, to challenge the tax that has been imposed by the WTO member if we believe it is discriminatory. What will we have to demonstrate to the adjudicator, say to the dispute settlement body of the WTO, in order to find a violation of this provision? So which tax will go contrary to Article 3.2, first sentence? So the products of the territory of a contracting party imported into the territory of another contracting party, this is simple, shall not be subject to internal taxes or other internal charges of any kind in excess of those applied to like domestic products. So what do we need to demonstrate? What are the elements that need to be demonstrated? Let's read how the appellate body in Canada Periodicals case approaches this. The appellate body says, there are two questions which need to be answered to determine whether there is a violation of Article 3.2, first sentence. First, whether imported and domestic products are like products. And the second question is whether the imported products are taxed in excess of the domestic product. If the answer to both questions if the answers to both questions are affirmative, there is a violation of Article 3.2, first sentence. So let's now write down this test in this table, which we will also fill in later with the test for Article 3.2, second sentence. So we need to demonstrate that the products are like. This is something we clearly need to show, because if the products are not like, they are not subject to these requirements. Like products can be taxed, unlike products can be taxed differently. Like products shall be treated in accordance with Article 3.2. Unlike products do not fall within the scope of it. And what is prohibited is taxation in excess. So we cannot tax a foreign product in excess to the tax burden that was imposed on the like domestic product. So like products, taxation and excess are the two elements that need to be demonstrated. Interestingly, the appellate body in Japan Alcoholic Beverages case says that we do not need additionally to show the protectionist goal, protectionist purpose that was behind this tax. There is no protectionist aims and effects that need to be demonstrated. It is part of the test within the first sentence that is already there. The appellate body says that the presence of the protective application need not be established separately from the specific requirements that are included in the first sentence in order to show that the text is inconsistent with the general principles set out there. So as for the protectionism intended, protectionism in application, we do not need to establish that separately. Just two elements, like products and taxation and excess. So this is a relatively simple test, and this is why lawyers like it that much, because you just need to demonstrate two elements if you want to challenge a foreign tax which you're unhappy with, if you believe that your product is discriminated against in the field of taxation, you just need to show that a like domestic product has been treated better, your foreign like product has been taxed in excess. Let's now understand what that would mean one by one. The most complex question, it is generally an extremely complex question that is subject to a lot of problems in application in various parts of the WTO rules. It is the concept of like products. I have already mentioned like products in Article 1. If you recall, they were also there. I did not touch upon that, and I invite you to do some additional reading at your end to find out what term like products would mean for Article 1. There are various approaches that have been implemented by the dispute settlement body. There have been different criteria proposed by the scholars. But generally, if you have the feeling of likeness in Article 3.2, you already understand the direction of a thought. Though Article 1 likeness is subject to different approaches. With Article 3.2, situation is much easier and much simpler. But even with Article 3.2, we need additional guidance to understand what is to be really helping us understand if the two products are like. So likeness between the products is a particular type of relationship that is there between these two products in a given market. Here are the two possible products. Well, the two highlighters. You see that they are only different in color. Are these two products like? Can they be subject to different taxes? That is a good question, because if we treat them as like, then every government that will introduce a tax on this type of highlighters will necessarily have to be very careful to introduce it with respect to all like products. Because if any foreign like product will be subject to a higher duty, then it will be a violation. It will be challenged to the WTO, and these rules will have to be removed with the risks of even negative consequences if the decision is not complied with. So as for these two highlighters, are they like or not? Well, you may have the feeling that, well, it is relatively simple. We would say they are most likely to be like. So yes, there is much of similarity. They are the same brand, it's just the color that is different. And in sense of taxation, we guess as they are more or less interchangeable, the majority would say they are like. Let me give you a more difficult question. Two cars, passenger cars, both passenger cars are cars that are very well sold and bought in Russia. So these are the most popular brands of cars among the Russian consumers, Lada Granta and Kia Rio. So these two cars fight for the same consumer, and they are both cars. You can use them for traveling, and they look very much similar, and in a way they are like, but they are produced by different producers. They are different in certain characteristics. They are even different in design. Does it render them unlike, or are they still like products? Let's make it even more difficult. If I give you not Kia Rio, but a BMW, would this type of a car be like as compared to Lada? Already not. And again, taxation may very well differ because there can be sales taxes on cars, there can be taxes on that there can be excise taxes on cars. There can be any form of taxation, any charges, any payments that will be levied on cars in a given jurisdiction. So if we understand that the two products are alike, then our legislator needs to treat them identically in sense of taxation. If we understand that the products are not like, then there is no restriction in sense of Article 3.2 first sentence for our legislator. So the legislators need to be very mindful of those product linkages when determining how taxation applies. Let's take even more difficult examples. Phones. So this is an iPhone and Sony Xperia phone. Well, many would say they are alike because people can use them to call, people can use them to send messages. They are smartphones, both of them are smartphones, and in a way they are interchangeable. However, many of Apple users would not be happy to switch to Sony, and I guess there are also Sony users who would not wish to switch to Apple products for various reasons. And there are two big groups of fans of this type of a phone or the other type of a phone that will fight hard saying that they're not like. But does it make it possible for us to treat them differently in sense of domestic taxation? If one product is produced in our territory and the other is produced in a different country, can we tax them differently? Can we introduce domestic charges? Again, don't mix it up with customs duties, because customs duties will only be applicable to an imported product at the moment of importation. But then there can also be domestic charges, excise taxes, sales taxes, or any other sort of taxes. In Denmark, there are taxes on fat products. So the fatter is the product, the higher is the tax. So taxes can be very different, and there is no international unity with respect to taxation. Taxes remain purely sovereign domain of states. No one can impact what taxes they charge and what are the tax burdens they charge. The only rules which we have in international law are rules prohibiting discrimination as between domestic products and foreign products as for charges. So we do not question the validity of the tax itself. We do not question the volume of tax, the burden that the tax imposes. We can only question the possible discrimination that this tax may implement. So iPhone and Sony Xperia, are they like or not? Big question mark. And then let's make it even more complicated. Rice and potatoes, are these two products like? Again, very questionable, because in a way we understand they look very different in all senses. They grow differently. They are used for different type of dishes, but ultimately in certain occasions they can be used interchangeable. In certain cultures, if you don't have rice, you can safely consume potatoes, or vice versa. But does it make them really like? So you see how difficult it is to really interpret this provision. And depending on the interpretation, we will have significant different legal consequences. Therefore, establishing product likeness is not an easy task, and determining if the two products are like or not is essential when determining whether we are in compliance or in violation of Article 3.2 first sentence. Let me give you one more example of a real case, though many of the previous examples were also real cases, and there was a big debate in the old GATT times about the likeness of luxury cars and ordinary cars. But as for the most fundamental example within the WTO dispute settlement system, it was the case called Japan Alcoholic Beverages. You see, it was not even the first case with respect to Japan alcoholic beverages taxation system. One was considered in the old GATT times. This one was among the first disputes within the WTO following the formation of the organization in 1995. And it was the first to develop the case law, jurisprudence, better said, because again, WTO dispute settlement system is not judicial, it's quasi-judicial, because ultimately, as you remember, all decisions are taken by members. There are no judges that are responsible for delivering compulsory decisions. So this first case that developed jurisprudence for WTO purposes was exactly Japan alcoholic beverages case. And it dealt with the Japanese liquor tax law as amended clearly in 1990s, and it was this law that was challenged by Canada, EC, and the United States. So what was actually the major bone of contention in that dispute? It related to a drink which is called shochu. Every time I mention this drink, someone in the room, whenever I tell the story to students, starts correcting me, saying, no, I guess you mean sake. No, I do not mean sake. I mean exactly shochu. Shochu, maybe this is the wrong way we pronounce it in English, and people from Japan would call it differently a little. It sounds a little different, but it is actually the Japanese distilled spirit, and it contains about 25% of alcohol, though actually some of its kinds can go up to 40% in alcohol content. And unlike sake, which is brewed alcohol made from rice only, this very shochu is made from many kinds of ingredients, such as sweet potatoes, barley, rice, buckwheat, whatnot. So this is also a famous drink in Japan, and this shochu was actually the bone of contention in that dispute I am mentioning. So what was the problem with this shochu? So what was the tax on shochu? I'm trying to give you the more or less comparable categories. However, you will see that the comparison is not, even the categories in that tax law were different with respect to domestic shochu, which is not produced elsewhere. At least it's de facto mainly produced in Japan, so it is clearly a de facto discriminatory mechanism if you see that it is taxed in excess as compared to the like foreign product, that the like foreign products is taxed in excess as compared to this shochu, because it is mainly produced in Japan. So the tax on shochu that was 31 degree of alcohol or above was about 200,000 yen, plus 26,000 yen for each degree above 30 degrees per 1 kiloliter. So this is the price of a tax that was charged on a drink per 1 kiloliter, and depending on the alcohol content, the tax would grow with the starting point being 203,400 yen per 1 kiloliter. Now let's see what were the tax burdens on the other distilled spirits, and especially those imported ones. So tax on whiskey, which is below 38. If whiskey was having even more alcohol in it, the tax would be even higher. So compare, it is not 200,000, it is 900,000 per 1 kiloliter. Insane. So the price of a tax is more than 4 times higher. But again, it will be a violation only if we believe that whiskey and shochu are like products. Then shochu is taxed more favorably than whiskey, and it shall not be then, this tax shall not be maintained, it shall be removed immediately once this violation is established. Or, well, there will be certain process, there will be some time maybe given for compliance if needed, if this immediate action would not be considered possible. But still, clearly, this tax would not stand if we establish that the two drinks are like shochu and whiskey. And then other distilled spirits, including, say, vodka, which was also part of the discussion in that case, it was also subject to tax, which was higher than tax on shochu. Tax on shochu was 200,000. For vodka, it is 367,000. And again, per the same 1 kiloliter. So depending on answering the question if the two products like or not, we end up either establishing a violation or not, because here we clearly see taxation in excess with respect to the like imported product. So the appellate body here was trying to rely on some criteria that have already been developed in the GATT times. The first time in the GATT practice that criteria of likeness were discussed happened long ago in 1970s. And it happened in the report of the GATT Working Party on border tax adjustments. Imagine we are back to the same question of border tax adjustments, because if you recall the text of Article 2.2a, it also refers to like products. It also implies that the two products of comparison shall be like. And therefore here, there was a need in 1970 already to develop certain criteria of likeness, to understand how likeness should be established. And in this case, the Working Party on Border Tax Adjustments adopted the following interpretation. Let's read it. The interpretation of the term should be examined on a case-by-case basis. So there cannot be any general rule that will apply across the board to all like products. It is always an exercise of a case-by-case analysis. This would allow a fair assessment in each case of the different elements that constitute a similar product. Well, a similar is not the correct word, right? The term is like products, so don't use the word similar products when you analyze Article 3.2, because again, we operate the term like products. But here it is just a euphemism to identify like products, not to keep repeating it again and again. Some criteria were suggested for determining on a case-by-case basis whether a product is like, similar. And those are the criteria that the Working Party on Border Tax Adjustments proposes. The product's end users in a given market, consumers' taste and habits, which change from country to country, the product's properties, nature, and quality. So at least we see three groups of principles, three groups of criteria that this Working Party report is proposing. End users of the products, how do we use the product? So yes, massage oil is also oil as compared to olive oil that we use for salads. But you would not likely use massage oil added into your salad. And well, some people do massage with olive oil, but this is not that common. So most of the two, though the two products are both called oils, they may be really different in a way that we could not consider them really like, in a way that they're very different in their products and uses. Then consumer tastes and habits. Do consumers treat products like or not? Do consumers believe that the two products are like? Or do they clearly understand they are not like? Would you feel the difference between a Jaguar car and a Lada car? I guess you would, even in cases they share many of the natural properties and characteristics. In sense of the material they were produced of, in sense of even potentially the power of the engine, but still you feel the difference. And there is this consumer perception that makes these two products potentially unlike. Apart from the fact they are different in price, what could also influence consumers' tastes and habits? And then the product's properties, nature and quality. It can be anything: taste, smell, color, whatever influences the likeness and non-likeness of the two products. Any physical characteristics, nature and quality of the products could matter. So here, the Japan Alcoholic Beverages Appellate Body analysis is based on those criteria as proposed by the GATT Working Party on border tax adjustments. They say, we agree with the practice under the GATT 1947 of determining whether imported products and domestic products are alike on a case-by-case basis. Then I omitted a part of the quotation because, again, just we are a little limited in sense of time and space. These criteria should be helpful in identifying on a case-by-case basis the range of like products that fall within the narrow limits of Article 3.2, first sentence. So what is important here? To begin with, it is important to understand that these criteria of likeness are relevant. So we keep these criteria as some sort of guidance. However, none of those is binding on the tribunal, none of those is decisive. And even if all the four criteria would tend to lead us to the conclusion that the products are like, it is not yet necessarily so. So it is always done on a case-by-case basis. It's the exercise to be done by the adjudicator, be that a legislator who develops the law or be that a WTO dispute settlement body. But clearly the WTO dispute settlement body could always check what domestic legislators decided and could question and even consider inappropriate the assessment made by the national authorities. So it's always a case-by-case exercise, and in two countries, the same group of products, the same pair of products could be like in one occasion and not like in the other occasion, because again, cases shall be different. Consumers will treat the two products differently. Products may be used differently in one and the other market. So it is not necessarily that once established likeness link of the two products will stand in the other case if a dispute arises. There is one more element that the appellate body in Japan Alcoholic Beverages adds to this criteria. That is the uniform tariff classification of products. They say that it can also be relevant in determining if the two products are alike. If sufficiently detailed, tariff classification can be a helpful sign of product similarity. So these are the elements that could help the interpreter understand whether the two products are alike or not. Once again, let's summarize these four criteria on a separate slide. Physical characteristics and quality of the final product. Again, we are talking of the two final products. We are not comparing the quality or physical characteristics of the inputs. So it's the physical characteristics of products: taste, shape, size, height, anything of the final product that could influence the likeness of the two products. Then consumers' taste and habits, which, as I said, can greatly differ in different jurisdictions. And in one market, consumers may treat products as like, whereas for the other market, they will not be like. 3. End uses of products, how the products are used in a given market. That can also greatly differ from one market to the other. And then uniform tariff classification also matters, because based on this uniform tariff classification from the harmonized system, and clearly not from the tariff bindings, which can be very different from one WTO member to the other WTO member, we could arrive to certain conclusions. So if we say that all the 4 criteria are heading us towards the conclusion that the two products are alike, then we could try convince either our national legislator or an international adjudicator in case of a WTO dispute that the two products are alike. However, as I said, it's always a case-by-case exercise, a little unpredictable in sense of the position to be taken by the dispute settlement body of the WTO. That all depends on the evidence based on these 4 criteria that the parties shall provide to the adjudicator. So what happened in that very case of alcoholic beverages, Japan alcoholic beverages? Vodka and shochu were found like. Why so? Because based on these 4 criteria, it was the conclusion that they share next to everything in respect of the perception in a given market, physical characteristics, and consumer perception. Shochu and whiskey and other liquors were not found like, because the panel and the appellate body later on identified noticeable differences in physical characteristics, noticeable differences in the use of the additives when the two products are produced, the use of ingredients, and even the appearance of the product that also matters for the determination of likeness. It may be the case that in certain situations there is no domestic product for comparison, and we could end up in a really awkward occasion when, because of the prohibition on importation, there are no imported products. For instance, as was in the case of Canada periodicals. However, it was still established that Article 3.2 was violated. It was the case that there were no imports of split-run editions of periodicals, because there was an import prohibition in the Tariff Code of Canada. But still, here in this case, and actually that in that case, that import prohibition was contrary to Article 11. We remember all restrictions on importation other than duties, taxes, or other charges are not permitted. However, even apart from that violation of Article 11, which was there because of the inappropriate import restriction, there was also a violation of Article 3. Well, there could be a violation of Article 3.2 if domestic and imported products could be subject to discriminatory taxation in favor of a domestic product. And here the appellate body says that hypothetical imports of split-run periodicals also have to be considered. Yes, there are no imports currently, but what would happen if there were imports? Would they be discriminated against as compared to the like domestic product or not? If they would, then necessarily we also have the violation, and there will be no problem in sense of the absence of the actual import for the comparison in sense of likeness. Then there was one more very important statement which was made by the panel in Indonesia autos, and it was not challenged, so it remains the finding that is standing. The panel was considering the situation when, right within the measure, the distinction was based on the origin of the product. So if we say that the product of one foreign origin is subject to a higher tax as compared to the like domestic products, if we say that all foreign products are subject to higher taxes, then it simplifies the work for the lawyers of the claimant. Because under the Indonesian car programs, the distinction between the products for tax purposes was based on such factors as the nationality of the producer or the origin of the parts. Again, it's all based on nationality and components contained in the product, the nationality of the producer and the origin of the parts and components. In our view, that's the position of the panel, such an origin-based distinction in respect of internal taxes suffices in itself to violate Article 3.2 without the need to demonstrate the existence of actually traded like products. This is directly in accord with the broad purposes of Article 3.2, first sentence. So when we talk of taxation, if we introduce a tax which has as a criteria of distinction between taxation, origin of products, then there is no need actually to go in the analysis of likeness. We presume that the two products are like. So we make this presumption just because there is no need to seek for these two groups of like products, for the reason that it clearly would end up in finding the group of two products that will be like, if the origin is the only criterion for distinguishing the tax burden. So this is as for likeness. And we will get back to likeness in a little while. Now let's see the second element of Article 3.2, first sentence. It is taxation in excess. And again, who is advising, who is assisting us here? It is Japan Alcoholic Beverages appellate body that is interpreting the term in excess. So we know the ordinary meaning of the term in excess, so when something exceeds the other level. So here the appellate body tries to make the more detailed interpretation of this provision and explain us what that means. The appellate body says the only remaining issue under Article 3.2, first sentence, if we establish that the two products are alike, is whether the taxes on imported products are in excess of those on like domestic products. If so, then the member has imposed the tax is in a manner not compliant with Article 3. And then comes the major part of this finding. Even the smallest amount of excess is too much. The prohibition of discriminatory taxes in Article 3.2, first sentence, is not conditional on trade effects test, nor is it qualified by a de minimis standard. So any difference in taxation, even the smallest cent that will be imposed in excess as compared to the like domestic product, will be problematic. Here, the big question is actually the methodology of comparison, and I'm not going in that detail. I invite you to do some reading on your own to understand how to compare the two products. Because when we talk of de facto discrimination, it is always difficult. Why so? Because on the one hand, we could compare one bottle of wine that is produced in Russia and the other bottle of wine that is produced, say, in Italy or in France, and we could establish that the Russian bottle of wine is taxed more favorably in a way. However, if we compare the group of all like products, the group of all Russian produced like wines, if we consider red wines to be like wines, all red wines are like. That may be not the case again, but let's say for the Russian market, all red wines, the division could be different. We could say that all, dry red wines will be like products, or all red wines from a particular wine grape could be like. It can be different, but let's say all red wines as Russian red wines and all Italian red wines, are they treated more favorably when we talk of the Russian products? And if we compare one product against one product, it is easier to establish a violation than when comparing a group of products as against a group of products, because again, there can be some difference, say, based on the wine grape, on alcohol content, but if we compare the whole group as against the whole group, we would not that easily establish discrimination. WTO dispute settlement jurisprudence has not been always very consistent on this methodology of comparison, but now most often the tendency is to compare a group of foreign products as against a group of the like domestic products. So we need to understand what are all those like products which would be falling within the group to make the proper comparison. And then, especially for de facto discrimination, it makes a lot of sense to first understand which are the like products, what is the group of the like products in total, and only then try to make the assessment if there is indeed overall discriminatory treatment, or if there has been just some minor occasions of maybe differential, let's say, taxation that is not that important when we compare the two groups vis-a-vis each other. So these are the two elements, just two elements, like products and taxation excess, nothing more required for the violation. So now let's talk of the first dispute, which actually happened very shortly after Russia joined the WTO in 2012. That was a funny case, which actually happened very quickly. There has been some ungrounded feeling that maybe there will not be a lot of dispute settlement procedures initiated against Russia shortly after it entered the WTO. There are these honeymoon so-called periods after a country joins the WTO, as if not used for dispute settlement procedures. It was absolutely not the case with Russia, but the reason is as follows. On the 1st of September 2012, less than a month after Russia actually joined the WTO, just immediately after Russia joined the WTO, to be honest, the Russian law on waste has been changed to introduce the so-called utilization fee or scrappage fee, as it is translated differently in different sources. What was the idea of this fee? The funny thing was that the fee was exactly at the amount of the reduction of import duties that happened following Russia's accession to the WTO. But the idea of the fee was to charge car producers for the future utilization, for the future scrappage of the fee, when the car in 20, 15, 30 years gets tumbled down and unusable. So the car, we have a lot of those unusable cars all over Russia. They need to be somehow utilized. They need to be scrapped. They need to be turned in scrap. And therefore, in this case, the story was that based on these announced ecological concerns, the fee was adopted. As I said, the major trick turned out that it was exactly to the amount of the reduction of customs duties. Unfortunately, not a very well tailored mechanism, quite straightforward. But still, it was impressive in sense of the size. It kept the protection at the same level, but it was impressive in sense of size. For passenger cars, it was something about maybe $600, but for trucks, it was impressive. It was about $5,000, and it could even question the margin of profitability of foreign products at all, because that was about the margin, near the margin. And even more, the fee would increase based on the age of the car. what is also not necessarily understandable, given that scrappage of the older car or the newer car may cost the same, though it is stated that modern cars are more eco-friendly. Therefore, maybe the cost for their utilization, their scrappage, shall be less. So again, not questioning the reasons behind this introduction of the fee. What was interesting and what actually makes it relevant under Article 3.2 of the GATT is that domestic producers were not subject to this fee. They did not pay the fee, they were not required to pay the fee, and they only guaranteed that in 20 years, when the car of their production gets unusable, they will take care of its utilization, of its scrappage. This was exactly what disturbed everyone, because one thing is to pay money immediately now out of the pocket, and the other is to guarantee scrappage in 20-30 years, because we don't know what happens in 20-30 years. We don't know if those producers are still alive, if they still exist, if there will be the same legal entities, if there will be any legal successors of them, or they're even through the bankruptcy proceedings, their assets can change the owner, and they could be sold without any proper legal succession. For whatever reason, understandable. European producers, and actually it was not only EU that was unhappy, it was also Japan and the United States that voiced their concerns and initiated the dispute against Russia. The producers from EU, Japan, and the US were not happy to pay the duty, whereas their like Russian domestic products were not made subject to it. And here clearly, because it was said that national producers are free from the tax, are free from the fee, from the charge, call it the way you wish, doesn't change the substance. So based on the finding by the appellate body in India Autos, we understand there is no even need to seek for the existence or non-existence of the like products. Clearly, it is the like product is there, and the foreign products are taxed in excess. They are taxed, whereas the like domestic products are not taxed at all. They undertake some obligation, regulatory obligation, and it was clear that this dispute is not really having big prospects, chances for success, actually from the first day it was introduced. And it's exactly what happened. You may see that less than a year passed when officially EU filed a dispute against Russia on the recycling fee. Following the unsuccessful informal discussion, there was a formal request for consultations. That is the first step of the dispute settlement process within the WTO. And the European Union notified the Secretariat on a request for consultations with the Russian Federation on measures imposed by Russia relating to a charge called recycling fee. Recycling here is the third option. Scrappage fee, utilization fee, recycling fee, imposed on motor vehicles. So following the unsuccessful consultations, and I had the pleasure of working on this case little already at the moment when the dispute was initiated. Following the unsuccessful consultations, a panel got established, and that was the second step to demonstrate the seriousness of the claimants with respect to this dispute. But at that moment in time, the Russian Federation already promised that this discrimination shall be abolished. And indeed, you may see that on the 25th of November, the panel was established. It is the first dispute against Russia. You may find it on the WTO website. And this WTO website still keeps the materials related to the dispute as far as the request for consultations was accepted. A number was assigned to this dispute, but the dispute didn't go any further because following these formal steps, the Russian Federation agreed to remove discrimination, and from the 1st of January next year, 2014, the new rules on the scrappage fee or this recycling fee got introduced, and all discrimination was eliminated. So as of today, both the domestic producers and the foreign producers do pay the tax, and the tax burden doesn't differ at all depending on the origin of the product, depending on the nationality of the producer. So now it is the example of the first dispute that was resolved in an amicable manner through these formal WTO dispute settlement mechanisms that were just initiated but never pursued to the stage of the panel hearings and any panel report, because it doesn't make sense to waste time on all that if the measure has already been changed so that to accommodate these discrimination concerns. So this is it with respect to the first sentence, like products, taxation in excess. Let's now switch to the second sentence of Article 3.2, which, as you may recall, contains a separate legal obligation. Having read it first, we would be puzzled because it would not be really easy to understand what was meant by the drafters. Let's first read it. It says, moreover, in addition to Article 3.2 first sentence, no contracting party shall otherwise apply internal taxes or other internal charges to imported or domestic products in a manner contrary to the principle set forth in paragraph 1. So what do we manage to understand otherwise? So there can be some other ways to apply taxes in a discriminatory fashion. Here we understand that the sentence directly refers to Article 3.1. So as to afford protection to domestic production, we cannot introduce any taxes with that purpose. And here it says we shall not apply with this in discriminatory intent. So if not even the intent, we should not apply it in a manner which would go contrary to the principle. So this is clear that one of the elements of the test here will be the application of the measure in the discriminatory fashion, in a way so that to afford protection to domestic production, as Article 3.1 says. However, what are the other elements? We don't really manage to understand anything, shall otherwise apply. One thing we could notice that there is no reference to like products here, right? So we only refer to what are the groups of products that we compare here. See, it's the third line, imported or domestic products. So we are comparing some products which are imported or domestic, but which are not like. So this is one substantial difference that is already clear. There will be some other relations in between the two products that are important, and we will clearly need to show the application in a manner contrary set forth in paragraph 1. And then at the end of this sentence, you may also see the asterisk. The asterisk always leads us to Annex I of the GATT, so-called add notes, additional notes on interpretation, supplementary provisions on the interpretation. If you recall our lecture on anti-dumping and countervailing duties, the determination of non-market economies was also in the add note. So if you have the text of the GATT in front of you, if you have it downloaded, you can scroll down to the very end of the file and find Annex I, which will deal with those supplementary notes and provisions on interpretation. So what does add note to Article 3.2 say if we read it at the end of the text of the GATT? So these are the elements, this one element that we already see. This is something we discussed. And add note now. Add Article 3.2. Let's read it and then I will give my comments. Add tax, conforming to the requirements of the first sentence of paragraph 2, would be considered to be inconsistent with the provisions of the second sentence only in cases where competition was involved between, on the one hand, the taxed product, and on the other hand, a directly competitive or substitutable product which was not similarly taxed. Does this provision say? It says that we could introduce a tax that will conform to the requirements of the first sentence, but it will violate the second one. When would it happen? When we have a situation of competition between the taxed product and the directly competitive or substitutable product, and we remember it was domestic and imported, right? Third lines, imported or domestic products which are directly competitive or substitutable. And the violation will happen if these two products were not similarly taxed. Let's write that down to our table with the tests of both provisions. So we here not talk of like products. We talk of directly competitive and substitutable products. This is something different, and we will have to establish what is meant by this category. We already understand what likeness is. Directly competitive and substitutable products stand for something different. Then, unlike taxation in excess in 3.2 first sentence, here we talk of not similar taxation. And not similar taxation would have a different meaning. Even from the English words used, you may have a feeling it appears to be a weaker obligation. Taxation in excess is much stronger, both in sense of prohibition of this de minimis, and generally the word in excess is harder in a way as compared to not similar. Not similarity implies certain flexibility. Keep in mind that in first sentence, we did not need to demonstrate the application in the manner contrary to principles set forth in paragraph 1, as the appellate body permitted us not to do that in case Japan alcoholic beverages. Here, it is not the case. Here, we would need to demonstrate that this particular tax is applied in a manner contrary to the principles set forth in paragraph 1. So it is applied with a view so as to afford protection to domestic production. So these are the two tests of the two sentences. They are really different. You see that they apply to different pairs of products. They imply different types of taxation that is not permitted. And then there is one additional element that we would need to demonstrate in Article 3.2 second sentence, which will be the application of a tax contrary to the principle set forth in paragraph 3.1, what we do not do when establishing the violation under the first sentence. We start with the term directly competitive and substitutable products. So we understand this is not something similar to likeness. It's a broader category. It is not likeness. It is more flexible. It is more, how could we say, it is less rigid than likeness, because again, we are talking of products which are competitive, but they are not necessarily like, because for the like products, the regime is clear. If the two products are like, no taxation in excess is possible. Here, these are some other products. This is a different pair of products that we care about. How would the alcoholic beverages appellate body approach it? They say the GATT 1994 is a commercial agreement, and the WTO is concerned, after all, with markets. It does not seem inappropriate to look at competition in the relevant markets as among a number of means of identifying the broader category, the broader than the like products, the broader category that might be described as directly competitive or substitutable. Nor does it seem inappropriate to examine elasticity of substitution as one of the means of examining those relevant markets. So these are the two criteria that have been identified by the appellate body, And these are the two criteria which are actually the major guiding tools. Again, I don't mean to say that there could not be any other criteria to be taken into account by the panel when considering the two products, whether they are directly competitive and substitutable or not. Interestingly, directly competitive or substitutable, actually, it's not that they should be both, it's either directly competitive or substitutable. And even from the terms we understand, so they should either directly compete or they shall be substitutable. So especially elasticity of substitution, especially the elasticity matters, because what is meant by elasticity? The readiness of consumers to switch from one product to the other. So the competition can be established by economic means, by economic analysis. And interestingly, if likeness is a pure legalistic category, when we say there is some criteria and we deal with this criteria, and again, it's very unclear how exactly you do that unless you do the legal interpretation in a particular case. Economic analysis in Article 3.2 second sentence may be far more transparent and clear because you just establish the fact that the two products compete for one and the same producer, for one and the same consumer, I'm sorry, and you also demonstrate that their demand is elastic. So consumers are ready to switch from one product to the other. These makes the two products directly competitive and substitutable. So the major evidence that will be provided to the adjudicator that needs to assess if the two products are directly competitive or substitutable or not is cross-price elasticity test. So they are essential for the analysis, and the teams of the parties will try to demonstrate that consumers really treat the two products as competitive. The two products, not consumers treat, the market actually considers the two products as competitive, just because with, say, the increase of the price in on one product, producers switch to the other product. So this exactly means the two products substitutable. So here, what also matters is the latent, extant, potential demand, which is still not there. So again, it is not necessarily so that we always have to show the existent demand and the existing relations of competition. Even potential competition here would also matter for the analysis. And it is particularly important if we get back to my example of rice and potatoes. I doubt that rice and potatoes could be found like products based on those criteria we developed. Physical characteristics. End users, very different. Consumer tastes and habits. Yes, in some markets, consumers may switch from potatoes to rice. Other markets, they clearly won't. I guess in the market of Vietnam or in the market of China, potatoes will never replace rice, whatever happens. And irrespective of the price of the rice, population will not choose potatoes instead for most of the traditional dishes. So in that sense, and then again, clearly customs classification of rice and potatoes is dramatically different. So clearly these two products have very little chance to be found like. However, could these two products be determined directly competitive or substitutable? The answer is yes, they clearly could be in a given market considered as competitive or substitutable. Especially, for instance, I guess in the market of Russia, it is more possible than in the market of, say, China or Vietnam, because in those markets, consumers do not feel that lighthearted when switching from rice to potatoes and backwards. So this is the type of analysis which is mainly done by the economists, economic studies, cross-price elasticity tests, and it will give a very clear understanding if the two products are directly competitive or substitutable. So this is first element that we need to demonstrate. The second element is not similar taxation. And we need to understand how different it is from the phrase used in the first sentence, taxation in excess. Here, the appellate body in alcoholic beverages again gives us a very good guidance. Let's read it, and I will give you some of the comments of mine. To interpret in excess of and not similarly taxed identically would deny any distinction between the first and the second sentence of Article 3.2. Thus, the appellate body says there may be some amount of taxation on imported products that may well be in excess of the tax on domestic-like products, but may not be so much as to compel a conclusion that directly competitive or substitutable products are not similarly taxed. This amount, this difference of what is not similar taxation actually, this term, this amount of differential taxation must be more than de minimis. Whether any particular differential amount of taxation is de minimis or not must be determined on a case-by-case basis. So here what is said that there can be certain difference in taxation and even in the tax burdens imposed. How much is it? I could not tell you as a general rule. It will greatly depend on the facts of the case, of the given case. However, whether any particular situation amounts to de minimis or not is only possible to analyze in the second sentence, because even a smallest excess, even a 1 ruble excess or a 1 cent excess in Article 3.1 suffices for a violation. In Article 3.2, when we compare two products like, say, rice and potatoes, could they be taxed differently, say, in Russia, if we consider these two products as substitutable? Yes, they could be taxed differently. Could imported rice be taxed in excess of the potatoes produced in Russia? Yes, potentially they could be. And there can be some difference in taxation, but it shall be de minimis. So it should be minimal and it should be explainable, understandable, so that the adjudicator would not have a feeling that ultimately this difference in taxation is actually aiming at protectionism. And that is exactly the third element we would need to demonstrate, applied contrary to the principles set forth in paragraph 1. And again, the same alcoholic beverages appellate body helps us a lot. So, an examination in any case of whether dissimilar taxation has been applied so as to afford protection requires a comprehensive and objective analysis of the structure and application of the measure in question. We believe it is possible to examine objectively the underlying criteria used in a particular tax measure, its structure, its overall application, to ascertain whether it is applied in a way that affords protection to domestic products. So what will matter? How will you determine that the products are taxed not similarly with a view to afford protection to domestic production? You see here the appellate body introduces everything possible in the scope of analysis. Structure, application of the measure, underlying criteria used, overall application. So here they will try to find out what is the rationale behind this difference. Is there any unclear rationale? Is there any feeling of discrimination? And why was this difference introduced when the two products were decided to be taxed differently? So what would matter? A lot would matter, actually. Would tax differentials matter, as I say here? Yes, they would. And may it be relevant to compare the other products that were regulated in this tax regulation to see what was the approach of the legislator with respect to other products and to try find out what was the logic here. Yes, it may matter. Seeing the overall structure of the legal act may matter. Would the level of tariffs on these products matter? It may matter also if we will see that one of the products was subject to more dramatic tariff cuts at the moment of the WTO accession. Would the intent of legislators and the regulators matter? Clearly, yes, it would. And this is why all those preparatory notes would be taken into account, all the clarifying letters that are supporting the proposed act in the course of its succession, in the course of its exception in the parliament, or state Duma, or however you call it. So yes, it matters. Therefore, even the statements in press that were made by some of the most active members of the parliament can be taken into account. So if they openly, and many members of the parliament like to be that open to admit that this or that law is adopted for the purposes of protectionism, it is adopted in order to assist our domestic industries. So even those statements would matter and can be taken into account in a WTO dispute. And exceptions would matter, because if there are certain exceptions which clearly exclude some of the similar products from the application of a tax, then the WTO adjudicator may have doubts in the good faith manner of the application of the tax. So here, it is important to analyze every evidence that is there with respect to the application of the measure, how it is applied, what is it applied, what are the products, and what are the relations as amongst these two products, apart from the newly adopted tax. So it's a really lengthy, complex exercise that is done by WTO adjudicators, and that is why their reports are that lengthy, because they have to go through all these criteria and they have to establish each and every element to make sure the tax is either in violation or in compliance with the WTO rules. So here are again these elements of the two sentences. So whenever we talk of any tax, charge, payment that is applied both to domestic and imported products, or at least that should be applied to both domestic and imported products, that is not related to crossing the border, we need to make sure that we clearly understand that there are two separate obligations that are there in Article 3, in the first sentence and in the second sentence. With respect to like products, no taxation in excess is possible, full stop. With respect to directly competitive and substitutable products, no unsimilar taxation is possible, given that the measure should also not be applied in a manner contrary to the principles set forth in paragraph 1 of Article 3. In both columns, elements are cumulative. You cannot skip one element and just be happy with the other one. So for the first sentence, 2 elements need to be established. For the second sentence, 3 elements need to be established. So when analyzing a tax, say in your exam question, you just first need to find out if the two products are like or not, if they're directly competitive or substitutable or not. And then you would need to go through the corresponding test depending on each of the columns that will be applicable. So what happened with shochu, whiskey, and liquors? You recall they were not found like products, but they were found directly competitive and substitutable. And there were several reasons. The appellate body and the panel, actually, and the appellate body supported this finding, was establishing in order to prove that. So they are directly competitive and substitutable for the following reasons. Both are distilled spirits, so they are competing in the same market. They also mentioned that the previous GATT panel in Japan alcohol case made the same findings. They established significant elasticity of substitution, and they, through other economic means, demonstrated that the products are essentially competing for the same market. So in that sense, the two products were considered like I'm sorry, they were not considered like, they were considered directly competitive and substitutable. And in that case, shochu and foreign products, foreign whiskey and foreign liquors were found to be not similarly taxed. So yes, the violation was established both with respect to shochu vodka pair and shochu whiskey and liquors pair, but the legal grounds were different. In one case, this was because the products were alike and there was taxation excess. In the other, because there was not similar taxation, contrary to the principle set forth in paragraph 1. So yes, violation can be found in both cases. Violation could be not found in any of the cases. So there is no direct link between the two. These are two separate legal obligations, which you should be very mindful of when approaching the exam questions on taxation that you may may have. Now from taxation to regulatory measures. And internal regulatory measures are covered in Article 3.4 of the GATT, and the article is also there on the text, on the slide. Let's read it and try and understand what is actually containing in this provision. So, internal regulatory measures are here at stake. It is no longer taxation that we talk about, so keep in mind those examples of discriminatory treatment in sense of offering for sale of products, placing a product on a shelf, putting a product in a separate fridge, sending a product through a more complicated route of transportation, whatever. So the products of the territory of any contracting party imported into the territory of any other contracting party shall be accorded treatment no less favorable than that accorded to like products of national origin. In respect of all laws, regulations, and requirements affecting their internal sale, offering for sale, purchase, transportation, distribution, or use. Full stop. Second sentence. The provisions of this paragraph shall not prevent the application of differential internal transportation charges, which are based exclusively on the economic operation of the means of transport and not on the nationality of the product. So we again see that in Article 3.4 there are two sentences. However, unlike in 3.2 in this provision, we do not see much of substantial obligation in the second sentence. It says the provisions of this paragraph shall not prevent the application of differential internal transportation charges. It just gives us some of the additional interpretative clarification with respect to the first sentence, and therefore would not really contain a separate legal obligation. So the conceptual legal obligation is in the first sentence. Let's once again try identify the elements of the test. So here we need to see that the foreign product is not accorded treatment less favorable than that accorded to like product of national origin. And the scope of the provision is that it applies with respect of, in respect of all laws, regulations, requirements, and I'm omitting these words, but they are also important because you every time need to check that there is some ground for your assessment conclusions. So in respect of all laws, regulations, and requirements affecting their internal sale, offering for sale, purchase, transportation, distribution, or use. So we understand that here we talk of like products again. We see this term here. This is something already helping us a little to find out what the test is. Then we see that the scope here will be limited to laws, regulations, requirements affecting certain matters. So we would need to demonstrate the existence of a law, a regulation, a requirement. And we would also need to demonstrate that foreign products are treated less favorably as compared to the like domestic products. So these are the three elements that we need to demonstrate in the first sentence. So getting once again back to the second sentence, notice that it has no legal obligation. It just interprets the term of the first sentence. And therefore, actually, unlike in Article 3.2, we would not consider any separate legal obligation from this provision. The structure of Article 3.4 is very different. The legal obligation is only in sentence 1, and therefore there will be no division as we had in the sentences of 3.2 here. The only obligation is in the first sentence, making things in a way simpler, but in a way more complicated. So I can safely erase the second sentence and write down the elements of the test. And the elements of the test were actually well established by the appellate body in Korea beef case, which we will just touch upon in several minutes. So let's just first read the finding from that appellate body report and then talk of the substance of the case. So for a violation of Article 3.4 to be established, 3 elements need to be satisfied. So that is exactly what we have already identified. The imported and domestic products at issue are like products. The measure at issue is a law, regulation, or requirement affecting their internal sale, offering for sale, purchase, transportation, distribution, or use. And 3, the imported products are accorded less favorable treatment than that accorded to like domestic products. So exactly the 3 elements that we identified, like products, laws, regulations, requirements, less favorable treatment. If I put them in a more common order of analysis, you may see it here. 1, 2, 3. That is it. So unlike in Article 3.2 first sentence, where we had 2 elements, here we have 3 elements. They are very different as compared to Article 3, right? And again, there is no need to demonstrate any application which was aimed at protectionism, any application contrary to the principle set forth in paragraph 1. So we just limit our analysis to these 3 basic elements, and if we establish the existence of all the 3 of them, then we have the violation of Article 3.4, and this measure will have to be removed by the other WTO members. So clearly, it is important for businesses to understand how it works, because it will be exactly businesses collecting evidence for disputes and supplying this evidence to their governments to understand how exactly governments within the system of the WTO dispute settlement would need to prove their case. So what was the story in this Korea beef case? I'm trying to give you in each of the provisions some brightest illustration. Here I chose the Korea beef, a very classical case. And it is something, again, you don't really understand as straightforwardly immediately. You don't have that in Korea any longer, but in 1999, Korea introduced the so-called dual retail system for the sale of beef. All imported beef should have been sold either in specialized stores that only sold imported beef, or in huge department stores where they could be kept in separate sales areas. And those stores which were selling imported beef should have been also tagged with a specialized import beef store sign. So that was actually the real measure adopted by Korea in 1999, and it was the reason behind the dispute that was initiated. So here, again, think of that from the perspective of Article 3.4, less favorable treatment, like products, and laws, regulations, and requirements. I was trying actually to find somewhere on internet any evidence of the existence of this dual retail system, any trace of it. But unfortunately, Google search, I didn't do it maybe that thoroughly, but I didn't manage to find neither the photo of a shop of this dual retail system or this sign of specialized imported beef store. However, I just was looking for some picture. Here is the bulgogi, which is the traditional Korean dish, clearly with beef. And well, this is just one of the examples of the fact that beef is very popular in Korea. And therefore, this dual retail system for sale of beef greatly influenced the sales of imported beef. Though I said that WTO doesn't care much about trade flows, and we don't really care much how dramatic market shares changed, increased, or decreased following the regulation. It may be noteworthy that the sales of imported beef dropped dramatically in Korea following the introduction of this retail system, because it was less reasonable for Korean businesses to start selling only imported beef if they were not huge department stores. And even for the big department stores, the rule on the need to equip a separate sales area could cause troubles. So here we would need now to demonstrate that this system was contrary to Article 3.4. But again, we may have a feeling that that this system is not discriminatory in a way. On the other hand, someone could say this is no problem because again, imported beef can be sold, they can still sell it. So is it really discrimination? So that is why we would need to go through the elements of the test, like products, less favorable treatment, and laws, regulations, and requirements. Like products, and here is the first problem, here is the first complexity. As you recall, Article 3.4 is structured differently as compared to Article 3.2. Reasonably, we would expect the term like products to be interpreted in the same fashion in all WTO provisions, right? It is reasonable. And we do not expect one and the same word to mean different content in the neighboring provisions. But that is actually what happens with respect to Article 3 and the term like products. I said already that like products are interpreted very differently in Article 1. And Article 3.2 and 3.4 are one more example of this, maybe not the best way of drafting the GATT, which results in such clumsy interpretations. However, they are necessary in sense of the regulatory purposes that are underlying the GATT. So here, legal techniques maybe leaves much to be desired in a way, but it has been sort of corrected by the interpretation implemented by the dispute settlement body. Let's read the finding of the appellate body in a C asbestos case. We will mention this case when we talk of Article 20 in one of the next lectures. The EC asbestos case appellate body was exactly stating the following. For us, the textual difference between paragraphs 2 and 4 has considerable implications for the meaning of the term like products in these two provisions. The textual difference is something that we already emphasized. It's the existence of the second obligation and the second sentence in 3.2 and the absence of this second obligation for directly competitive and substitutable products in Article 3.4. So if we would read Article 3.4 in a narrow fashion, and likeness shall be interpreted also very narrowly, we would have to arrive to the conclusion that directly competitive and substitutable products are not covered by Article 3.4, right? Because it's a different term, it has a different meaning, it does not overlap with the term likeness in 3.2, and as long as there is no second sentence in Article 3.4, and there is no direct reference to directly competitive and substitutable products, then in sense of regulatory measures, the scope of national treatment is narrower. It only applies to like products and does not apply to directly competitive and substitutable products. However, this is not what the appellate body wishes to adopt. They say the general principle articulated in Article 3.1 is expressed in Article 3.4 not through two distinct obligations, as in two sentences in Article 3.2, but instead through a single obligation that applies solely to like products. So here they try to say that the scope of the obligation should not differ in 3.2 and 3.4 because the general principle in 3.1 is the same. So they want to interpret the term likeness in 3.4 in a manner that would still permit comply with the general principle in 3.1. And thus, they conclude that given the textual difference between articles 3.2 and 3.4, and here is the phrase which I appreciate a lot, the accordion of likeness stretches in a different way in Article 3.4. So there is an accordion of likeness that stretches, and the accordion of likeness in 3.4 stretches in a wider fashion than it actually stretched in 3.2. So here in 3.4, the accordion of likeness seems to be much more stretchable. How exactly does it stretch? Here is luckily the explanation that follows. As products that are in competitive relationship in the marketplace could be affected through treatment of imports less favorable than the treatment accorded to domestic products, so in respect of laws, regulations, requirements, as competitive products that have competitive relationship could be affected negatively through a less favorable treatment, it follows for the appellate body that the word like in Article 3.4 is to be interpreted to apply to products that are in such a competitive relationship. Thus, a determination of likeness under 3.4 is fundamentally a determination about the nature and extent of a competitive relationship between and among products. So, what does the appellate body say? Here the appellate body says that likeness in 3.4 is very different from likeness in 3.2. And here likeness means competitive relationship between the two products. Same cross-price elasticity test. So the two products will be considered as like for the purposes of 3.4 if they compete for the same consumer. And again, this interpretation is based on this shortcoming of the text of Article 3.4, which does not contain the second sentence. So in order to overcome this difficulty and in order to ensure that the scope of national treatment obligation doesn't differ for regulatory measures and for tax measures, for fiscal measures, there is a need to interpret Article 3.4 term like differently. So for Article 3.4, likeness is competitive relationship. We do not, well, we can implement those criteria. We can analyze those criteria. And tribunals do that. The appellate body and the panels do analyze those 4 criteria of likeness, but ultimately what is most important for them is not the physical characteristics, not the end users or whatever. What makes utmost choice, what influences the utmost decision, is whether there is competitive relationship as amongst the 2 products. Yes, I understand that it is very difficult to comprehend. It is difficult to accept the fact that the same words can be read differently in the neighboring provisions. But this is what we have to deal with. This is what we have to accept for the reasons that the structure of the agreement, unfortunately or fortunately, is different. And the appellate body wishes to avoid some disproportionality in national treatment scope. Therefore, here, when we talk of national treatment, we need to keep in mind that likeness in 3.2 and in 3.4 is different. This accordion stretches differently, and for 3.4, competitive relationship is most important. Whereas other likeness criteria will be taken into account, but to a lesser extent shall they influence the understanding of the 2 products as like for the purposes of 3.4. Then, less favorable treatment. Not much left, just 2 more criteria. The first one, less favorable treatment. And this is exactly what is most tricky in the case of Korea beef, because you could say, but again, foreign products could be sold, domestic products could be sold, a separate shop could be established for domestic products, a separate shop could be established for imported products. What's the problem? What's all the fuss about? Here is how the appellate body approaches the concept of less favorable treatment. What is it? I many times emphasized we are not speaking of drop in sales or drop in trade flows. Most importantly is something different that the appellate body highlights here. A measure that provides treatment to imported products that is different from that accorded to like products is not necessarily inconsistent with Article 3.4, as long as the treatment provided by the measure is not less favorable. So not any difference in treatment necessarily results in less favorable treatment. That is important because treatment of 2 like products can be different. But we need to understand if this treatment results in less favorable treatment. A formal difference in treatment between imported like and like domestic products is thus neither necessary nor sufficient to show the violation. So it's not the formal difference that matters. Whether or not imported products are treated less favorably than the like domestic products should be assessed instead by examining whether a measure modifies the conditions of competition in the relevant market to the detriment of the imported product. So here it is very important, please remember this. That is the test for less favorable treatment. Modification of conditions of competition to the detriment of the imported product. So following the introduction of the measure, conditions of competition have changed, and they have changed to the detriment of the imported product. Again, it does not mean that the imported product is now worse off as compared to its position before. The imported product can be so popular and so interesting to your domestic consumers that they are still buying it and sales maximize and increase. However, there can still be modification of conditions of competition to the detriment of the imported product. And this is what we need to check. Because if there is this modification, then this is exactly what would be prohibited by Article 3.4. And the last element of the analysis: laws, regulations, and requirements affecting internal sale, offering for sale, purchase, transportation, distribution, or use. Well, I'm not going now to talk about the word affecting. I guess it is relatively understandable to any adequate person what could be considered as affecting or non-affecting. However, there have been certain disputes, but let's put it aside because this is more technical minor matters. What is most important is that the form of this regulatory measure, which we want to challenge, which we question with respect to its validity under Article 3.4, should be either a law or a regulation or a requirement. And again, that is a very important part of the analysis. The form matters. A law, a regulation, or a requirement. What is different between these three words, and how do we determine what is a law, what is a regulation, what is a requirement? Actually, I guess it is also quite intuitive that a law is likely to be an act that would be adopted by the legislative authority. A regulation is more likely to be adopted by some administrative authorities or some executive authorities. But again, don't forget that the word is very different, and there can be countries not having any legislative authorities. There can be a monarch that just enacts any sort of a law or an act, or however he calls it, she calls it. So law, regulations, as our dispute settlement panels have analyzed, are just situations of legally enforceable rules of conduct under the domestic legal system of any WTO member concerned. So it can be any sort of a law or a regulation. As I said, usually, frankly, in practice, they do not distinguish between these two, as long as we do not see any difference in this split in legislative and executive authorities, which are present in many countries still. The trickiest word is requirement, because if a law and regulation is straightforward and we understand it is legally enforceable, the requirement is more tricky. Because when we say a requirement, we may have a feeling that something is required, but it is not compulsory. So a requirement may mean, potentially, may mean something not legally enforceable, right? So that could be one of the options. And here is how the panel in India Autos case understands the requirement. The panel says that actually a requirement could be one of the two situations. Either an obligation which an enterprise is legally bound to carry out could also be considered a requirement. It can contain in some act, it can be located in some act of a lower position in hierarchy of domestic legal systems, but still be legally binding. But on the other hand, according to the panel in India Autos, requirements could also be situations of those situations when enterprises voluntarily accept those requirements in order to obtain an advantage from the government. So requirements can be very different. Well, I could give you one example that I've been working with, the Russian system of subsidies. That is the system of subsidies for agricultural machinery. One of the criteria for the eligibility of these subsidies was as follows. I guess you may know that all vehicles are subject to certain environmental requirements. And there are certain environmental classes, there are certain environmental thresholds that are determined by the United Nations, and they're depending on the amount of greenhouse gases emitted in the combustion of fuel by a car engine. You would have a certain ecological class assigned to a vehicle. So these classes are called Euro 4, Euro 5, Euro 6, for instance. And the less emissions, the higher is the class. Euro 6 is the least pollutive. Euro 4, Euro 2 is most pollutive. Euro 1, Euro 0 could also be possible. And not all countries implement this system, and many countries don't, and many countries are not willing to, well, especially some least developed countries are not willing to pay more for these engines, which are more environmental friendly. The more developed the country is, the more likely it is to adopt higher standards of environmental protection. And I could give you the example that, for instance, in Russia, the obligatory level is, say, Euro 5. And then in the system of subsidies, it could be a ground to be eligible for a subsidy that you need to demonstrate that your environmental class is higher, Euro 6. So is it compulsory for you to place your tractor in a market? No, it is not. Can you sell a tractor with Euro 5 ecological class? Yes, you can, easily. But you will not be eligible for the subsidy. The subsidy is not, again, something you necessarily need to get. You can safely live without the subsidy. You can perfectly sell your products and be popular and be effective in a market. But if you wish to get this advantage, if you want to obtain an advantage, you may voluntarily accept this requirement. It is not compulsory, it is not mandatory for everyone. It is not the minimum threshold necessary for selling the product in Russia. But it is something that you may wish to comply with, you may wish to voluntarily accept in order to obtain an advantage. So that could be considered a requirement in the sense of Article 3.4. So like products, less favorable treatment, and laws, regulations, and requirements. Form really matters, because unless it's a law or regulation or requirement, you would not manage to establish a violation. All the three elements are cumulative. You cannot drop any of those. So some of the examples from our lives. Indonesia introduces a regulation. Here are the details. What does it actually do? It obliges modern retailers to ensure that at least 80% of products, of goods sold in those shops, are domestically produced. So they introduce a quota of 80% on the sale of domestic products in shops. And here my question is, do you consider that to be a violation of Article 11, quotas, prohibition of quantitative restrictions, or Article 3, national treatment, or are both violated? And in order to answer this question, you need to recollect the provisions of Article 11, which we discussed before in the lecture on quantitative restrictions. It is important that you keep in mind that Article 11 deals with prohibitions or restrictions on importation and exportation, and that is essential. So it only relates to questions that are about entering the border or leaving the territory, entering the territory or leaving the territory, crossing the border. It does not relate to internal sale, offering for sale, distribution, transportation, or use. With respect to all these questions, it will be Article 3 that shall apply. Article 11 and Article 3 cannot apply immediately simultaneously to one and the same problem. If it's an internal measure, then Article 3 applies. If it affects internal sale, offering for sale, distribution, transportation, or use. And even though it is a quota, so it introduces some numerical limit, it does not make it Article 11 matter. Article 11 relates to border measures with respect to importation and exportation. So don't confuse the two. Don't make this mistake, because once you see this, that something is a quota, you are tempted to apply Article 11. It is not the case when we talk of domestic sales, offering for sales, distribution, transportation, or use. Here, the governing provision is Article 3. Could I give you some examples of the other measures which are enforced and which are very questionable in the context of Article 3? Here it is. Russia, Federal Law on Advertisement, Article 21. It specifically says that advertisement of wine in printed press and on TV is prohibited with the exception of wine produced in Russia. So this is a clear situation when we have the discrimination purely based on origin. We would be even able to assume likeness. Then we clearly understand that it is less favorable treatment because a foreign product cannot access certain advertisement market, and it's a law, federal law on advertisement. So laws, regulations, requirements, this element is also here. So that is the type of analysis you need to go through when reviewing regulatory measures. Once again, taxes, 3.2, taxes, charges, payments. Regulatory measures, administrative measures, 3.4. Not immediately and simultaneously. Depending on the content, you either choose one or the other. And the last but not least, let's consider the situation which is here on the slide. Or let me give you a different situation. Imagine that in each and every interview, the Russian president emphasizes, being asked or not, he says, Russian cars are very good. I myself drive Lada. I invite everyone to drive Lada. And I wish to say that foreign cars are very bad. German cars are terrible. I lived in Germany. I know what I say. They are always, they are very expensive. They break. They are difficult in maintenance. Don't buy German cars, buy Ladas only. How would you treat this situation from the perspective of Article 3, national treatment? Once again, put a video on pause for a while, take a minute to think about it from your own perspective, because this is the type of questions you may have during the exam. So once again, the president keeps speaking in his each and every interview, whenever asked or not, that foreign cars are very bad, foreign cars should not be purchased. He invites, he insists, he wishes everyone to buy Russian car Lada. Do you consider this to be contrary to the principles of Article 3? Well, to begin with, we understand that there can be, we feel there can be some discrimination, and even with the fact that some bad words are said about a foreign car, foreign brand, it may be disadvantageous. Secondly, this may have impact on the sales of Lada, because someone may take these words seriously and may even wish to purchase Lada following this advice. So there can be an element of less favorable treatment. We clearly understand that it is not a story of Article 3.2, it is not a fiscal measure. We understand that there is a product here in this scenario in any case, because again, as India out as appellate body says, it's enough just to demonstrate, Indonesia out, I'm sorry, enough to demonstrate the existence of the discrimination which is based on origin. We straightforwardly here say Russian good, foreign bad. But what about the form? That is the trick, because here we do not have a law, a regulation, or a requirement. There is no incentive anyone could really expect when following the advice of the president. There is no law, there is no regulation. So even though this rule, even though this situation is not very good in sense of non-discrimination, and it smells with discrimination, but still we would not have any legal grounds under Article 3 to challenge it. I do not mean to say there will be no mechanism at all available, and we will talk about it in one of our last lectures, I think the last lecture. But actually, from the perspective of Article 3, you would not manage to do much. All the elements in 3.4 are necessary, and one is missing: law, regulation, and requirement. And as long as you don't have either a law or a regulation or a requirement, Article 3.4 doesn't fly. In that sense, we need to make sure that we remember those tests, we apply them correctly, and we do not miss the elements, because once any of the elements is missing, there will be no chance for us to apply the provision. Even though we feel it's discriminatory, not much could be done about it. So that is it with respect to the tests in National Treatment Provision, Article 3. And we now need to understand what are those measures which are exceptions, or better said, exemptions from these general national treatment obligations, which forms part of the fundamental WTO non-discrimination provisions.